MiCA. We're gonna deep dive now really into the topic of MiCA regulatory technical standards, and we're gonna do that with another representative from the European Supervisory Authorities, in this case from ESMA, and our representatives from Ripple and from Coinbase that are joining on stage, our moderator, professor from the Università Bocconi and founder of the Blockchain Lawyers Group, Francesco Patti. So I will welcome everyone on stage and then let you all introduce yourself and kick off the debate. Thank you all, a big round of applause.
So I think it's we can start directly in asking to Julien, which are the challenges that ESMA is working on in this moment? A lot of members of ESMA are working on these implementations. It's an incredible effort. We've seen the first consultations, the first writings. And can you talk a bit about how challenging it is to implementing this MiCA provisions?
Yeah, sure. I hope you hear me, or yeah. So yeah, thank you very much, and good morning, everyone. Yes, indeed, it could be quite challenging, but as my colleague from EBA, Elizabeth, mentioned, actually the challenges are the same for everybody. As you know, MiCA will come into application in December 2024, and 2024 is coming very fast. So I mean, the first challenge, of course, is the timelines. But we are working on that with the EBA and the IOPA, and that's why also we launched this consultation, public consultation package, and we divided this consultation. And I have to say that this progressivity in the application of MiCA is very helpful for us. So of course, workload on timelines are maybe the main issues. But also another challenge is actually the content of the level 2 and level 3 text, if I say themselves, because actually sometimes crypto can be a brand new world, and it's difficult to take inspiration from the existing regulation or the existing level 2 text or level 3 text, for example, in MiFID or other regulation, because sometimes it just it doesn't work. Sorry. So actually, that's the reason why we need actually a good comprehension of the technology, a good comprehension of the business model behind actually the crypto assets activity, and that's how we proceed actually at ESMA. Because if we just focus on how we worked. Actually, we are working with, of course, closely with NCA, so with National Competent Authority, in order to have concrete use cases, in order to work on concrete, business model cases, and of course to promote convergence when it comes to these concrete use cases. We're also working with the industry. We have been meeting the industry in order to better understand also the market. And actually, we use all the tools we've got. It means that the standing committees we've got at the ESMA, and especially the Digital Finance Committee, which actually is responsible for all these innovative related topics. So with NCAs, we are working on this challenge all together, on this MiCA interpretation issue sometimes. And we also, at the ESMA, created a dedicated team called the Digital Finance and Innovation Team, who is responsible for this particular topic. But most of all, in order to work and to address all this challenge, we do not work at ESMA, I mean, in silos. I mean, we are working, of course, with the EBA, we are working with IOPA, but even internally, we have involved, we have gathered a range of expertise, of different expertise, sustainability experts, for example, colleagues from investor protection, colleagues from asset management, and we are all working on this piece of regulation.
Okay, great. Thank you very much for this overview. We're also going to dive into some selected topic. But first, it's also important to look at the other perspective. Like on the other side, we have the industry who is waiting for this implementations. And we have here Katie Harries, which is Director of International Affairs for Coinbase. And I want to ask you, like, how is the situation? You're trying to follow the works, and which are the challenges for the industry that will have to comply with these technical standards?
Yeah, just taking a step back first, just to reiterate the comments that Caroline made on the previous panel. MiCA is a hugely significant step for the industry in terms of providing the legal and regulatory certainty to the market so that firms like Coinbase have the confidence to invest and grow across the region. And one of the innovations of MiCA is that we will be able to service the whole market from one member state with one regulator. And that's a hugely significant moment. So in terms of how Coinbase is thinking about the path to a MiCA license, I should say from the outset that we haven't yet made a decision on our MiCA entity location. But just to give you a sense of our footprint, we have an e-money license in Ireland, we have a crypto license in Germany, and a number of national registrations across the EU. And in terms of looking forward, in terms of deciding where we will establish our MiCA entity, we're considering a number of member states who all have sophisticated regulators with a lot of experience in terms of regulating financial services. And so going back again to some of the comments I made in the previous panel, I think one of the biggest challenges with MiCA is that whilst it provides a single rule book across the EU, supervision still remains at national level. And I think one of the challenges is going to be around the risk of supervisory divergence. And I think the first instance in which we will see this is the path to a MiCA license. And I think it's really important that member states don't rush to award MiCA license as kind of a competitive play to attract firms to their jurisdiction. And it's really important that all firms that are awarded a MiCA license are compliant with MiCA. And I think just more generally, there's a big debate in the EU around the grandfathering period, whether it should be 18 months or whether it should be shortened. Coming from the industry perspective, I think MiCA is going to be a big uplift for most firms. I think we're as well positioned as any to transition to a MiCA license, but it is a significant uplift and a change for the industry. And I think firms are going to need that runway to implement the provisions in MiCA, particularly as some of the RTS aren't due to be published until the end of next year. So we'll need to see those requirements before we can implement them in time. So I think from an industry perspective, the 18-month period is probably necessary. But then equally from a supervisory perspective, MiCA's new for supervisors too. And again, we're hearing from supervisors that there are some concerns about having the resources necessary to process applications. So I think both from a supervisory and from a firm perspective, I think the 18-month period makes sense. I think the challenge is going to be if different member states take different approaches to the 18-month grandfathering period. So you may have a situation where you've applied for a MiCA license in one member state that potentially is taking longer to award those MiCA licenses, and yet in other member states, they're shortening the grandfathering period. So what does that mean for firms in terms of the business disruption that might take place while you're waiting for the MiCA license? So I would suggest that it would be very helpful if member states could take similar approaches to the grandfathering period, and there's a consistency in approach on that.
Yeah, that's a great point, because obviously it requires a lot of organization, not only for the people that have to, for the enterprises that have to comply with these rules, but also for the regulators, for the authorities to implement a MiCA authorization process, which in many countries does not exist today. And therefore, these 18 months, I also agree, are also needed in order to organize everything well, considering that in many countries we have a lot of registered entities that will need to understand what to do. And so I agree with you. It's an opt-out system, and I'm very curious to see what the member states will do. But now let's look behind technical standards with an outlook. Andrew, what do you think will happen once the technical standards will be there?
Yeah, well, thank you for. No, thank you for that. I have to say, I basically agree with everything Katie just said, so I'm gonna have to think of something else to say right now. But I think the important thing, so MiCA does two things, right? MiCA firstly creates a regime for crypto assets. That's what we will talk about. That's ultimately why we're here. But it creates a European regime, and that's the important thing here. It's a single European regime that makes it much simpler for firms, be they European, be they international, to do business across the EU from one place. So the most important thing throughout the entire MiCA process, from the development of the original proposal through the legislative process, and now through the level 2, level 3, and then implementation, is that we keep this focus on a European framework and make sure there is no divergence between different member states and different supervisory authorities. So I think where we are today, and taking your question, where we are today at the development of RTS, okay, that's a single rulebook. We'll talk about that in a bit more detail in a second, I think. What matters is then how the different NCAs, national competent authorities, put this into practice. And I would argue that the ESAs have a role here in helping force convergence or at least stop divergence and helping coordinate different supervisory authorities amongst themselves. Now, that could be a bit of a hard sell because generally national competent authorities, want to cooperate, of course, in the European system, but also are quite rightly cautious about protecting their own consumers, their own citizens. That's their mandate, that's their job. But there is a space for perhaps informal or more formal coordination from the ESAs to make sure that some of the stuff that Katie was talking about doesn't come about in terms of different timelines, in terms of different approaches towards the awarding of licenses, in terms of the actual application of the rules in the end. So I think it's very important. So, for example, the Irish Department of Finance came out with a consultation very recently talking about some of these issues, looking at the grandfathering arrangements, the transposition timelines, but also asking a very interesting question, which is which authority or what level can which institution has the ability to determine that a given national regime is MiCA compliant? And we're talking here on the public sector side, not obviously the firms. That comes afterwards. And I think there's a very real risk here that if, in a sense, individual jurisdictions are able to mark their own homework and say, we already have a MiCA compliant regime, that will distort the single market or lead to an unlevel playing field, because in those circumstances, a firm would potentially get a benefit from being based in one European country compared to being based in another European country, just because of the location of their incorporation. And that doesn't seem to me a particularly it's not a very European solution to MiCA, and it would, I think, ultimately mean that the level 2, 3 process slightly goes away from the overall objectives of the MiCA level 1 text, which is, as I say, to create a European regulatory framework for crypto.
I want to stress a bit this point, this situation in which we have different parameters applied in the different jurisdictions. We have to be frank on this point. We have this situation also today. We don't have a normalized framework for authorization of crypto asset service providers, but we have AML rules that are applied in a different way in the different jurisdictions. And if you see the registered CASPs, for example, in some countries, you see a huge amount of enterprises. For instance, in Italy, I talk about my country, 125 CASPs are registered. And in other countries, for instance, Germany, only 7, in France, 95, in Lithuania, 400. And so there was an arbitrage, which I think depends a bit on the ease of getting this registration, and a bit also external conditions, which will play out also for MiCA. But this is, I think, a fundamental aspect, like how to create a level playing field, which is competitive, and where we don't have situations in which industry members take advantage in going to one jurisdiction because they know this one will work better. How do you address this problem at Coinbase, or if you want to give an opinion on this, Katie?
Yeah, no, I think risk of unlevel playing field, supervisory divergence is a really big risk in MiCA, and there are certain areas where we think this is just super important that ESMA and the ESAs are very focused on. Just to give you a few examples of the areas that we see, drawing on the comments that Elizabeth made on the previous panel, token mapping is incredibly important. I think the EU has already decided that a separate regulation was needed for crypto assets, but whether these assets fall within MiFID or MiCA is still a bit uncertain. And I think the guidelines that the ESAs have to produce will be absolutely critical in that regard. I think perhaps an outside risk that there's a really big debate within Europe. I think it's largely settled, but on the margins there might be issues. And if there are divergence between member states, I think that will have a significant impact on the single market. So I was very pleased to hear that the ESAs are very focused on that particular work. And then just to give a few other examples, conflicts of interest. We have seen the paper that ESMA produced recently in terms of the approach that the EU is planning to take. I thought it was a very proportionate and appropriate approach in terms of putting the onus on CASPs to identify, to manage and disclose conflicts of interest. I think it was very positive that they recognized that certain combinations are more risky than others. I think there was some recognition that custody plus exchange, there are potential benefits of that in terms of instant settlement, but there may be riskier combinations, for example, exchange and market making or exchange and broker. And that there are measures that can be taken to manage those conflicts of interest. They don't need to be eliminated. We see conflicts in TradFi, and measures are taken to manage that appropriately. So I think the approach that ESMA is considering is a very appropriate one. I think the concern is that this is an open debate at global level at IOSCO. We don't yet know where those final principles will land. And I think the concern for us is if member states decide to kind of gold plate the European standard on conflicts of interest. Again, it's such a critical issue in terms of the structure of the market that could have significant distortions in terms of the single market. And then just finally, give another example, if I may, which is around custody location requirements. We're seeing some debate in terms of the extent to which custody arrangements should be onshore, just generally globally. I think MiCA requires EU custodians to have a MiCA license, which we think that's the right approach. But what we're hearing from some member states is that it's absolutely appropriate that firms should be able to deploy infrastructure or technology within the wider group. And again, I think there's a potential that different member states may take different approaches to that, and it would be very helpful if ESMA could clarify that that's absolutely appropriate and compliant with the rules that are set out in MiCA.
Thanks, Katie. So I would say let's dive a bit into this technical standards, and one aspect which comes out frequently into the MiCA text is the sustainability problem. We all know the process that led to these provisions. It seemed for a while that there would have been a ban for a certain type of blockchains, of consensus mechanisms. It was not the case finally, but we see that there is a lot of importance which is put on the problem of sustainability. And so this, I think it's a very interesting question for Andrew. And what are your thoughts on the point?
Yeah, well, look, I mean, it's great that the EU has created this in MiCA and is mandating the ESAs to look at sustainability indicators. As you referenced, we all know what happened in the European Parliament during the MiCA negotiations. I think, we were all, presumably everyone in this room or listening, was concerned that there was going to be some sort of ban on a technology type rather than looking, as we all talk about, the activities, the risks, and the potential mitigants of those risks, or the regulatory outcome you're looking for. So, it's a very important conversation that was had. I think it's ended up in a good way, which is saying, this is important. It is right for the ESAs to look into this and to create some kind of transparency around sustainability profiles of different blockchains and users. But of course, we shouldn't be regulating technology. I think most jurisdictions globally agree with that. When it comes to the sustainability indicators itself, what matters then is, I would say, is that users of a given technology understand what the sustainability profile is of it. So what we need to ensure when sort of developing these sustainability indicators, the RTS, is that these don't become a ban by the actor or some form of regulation through particularly onerous or specific requirements for the indicators. And I don't think that's anyone's intention, but it's often possible to get unintended consequences and things. So for me, the most important thing is that they provide very clear information in a comparable way across different types of technology so that the user knows what they're getting. And I think that needs to be set against the sort of indicator of sustainability profile of a blockchain needs to be set against the value that blockchain can provide. Because on its own, just saying XYZ uses more or less energy than something else doesn't tell you very much if one of them is creating a Bored Ape and the other one is helping send remittances to Africa or helping a blockchain do carbon credit tracking, for example. So the value, I would say the ESG value, the environmental societal value of the blockchain needs to be set against the sustainability profile. So I think it's important that any indicator takes into account both those sides. And then finally, what I'd say is this needs to be an international piece of work. EU rules in the space have to, where possible, where there is already something, draw from international standards. And of course, as much as is possible, we need to get the EU RTS embedded into international standards, because it won't work if there's one set of rules in the EU and there's one set of rules elsewhere, or no rules elsewhere.
Thank you very much. Thank you very much. And now I have another question. It's very important concerning the scope of application. There is a big divide into MiCA. We know that MiCA applies in a, we could say, residual way, like even only if we're talking about a crypto asset which does not undergo other European rules, and predominantly which is not regulated by MiFID in the terms of financial instruments. And so this poses an incredible problem of token classification, which I think becomes more and more dramatic at a national level, because the understanding of financial instrument is not really harmonized in the national states. And we know that ESMA is working also on the part of token classification in order to give some guidelines, technical standards to understand how the token can be classified. I don't expect that you clarify every aspect, Julien, because we have only 8 or 9 minutes. But nonetheless, I think it's very interesting to know which is the methodology that you're adopting to try to give guidance with respect to this huge problem of MiCA.
Yeah, actually, it's a traditional methodology, to be honest, because as you know, and as Patti mentioned, actually the work of ESMA is to promote convergence. I mean, we are involved in promoting supervisory convergence in order to have a reasonable level of harmonization across the EU and to avoid the risk of what we call forum shopping across the EU. And for example, the grandfathering clause and more generally the transitional measures in MiCA is a perfect example of the need of convergence, because as you mentioned, there is a risk here, and we need to come. Well, actually, we need a smooth implementation of MiCA, and we need a level playing field across the EU. Sometimes it could be complicated with these 18 months periods. But another example, or a good example, and it has been mentioned actually by Elizabeth, is the classification, because we are involved in this topic with the EBA when it comes to asset reference token, and also guidelines, dedicated guidelines, will be published in Q1 2024, because it will be part of the 3rd consultation package on the classification of crypto assets as financial instrument. And to be honest, this work, it could be sometimes quite challenging for several reasons. And the main ones being that actually, as you know, the financial instrument, the concept of financial instrument, the notion of financial instrument is not harmonized across the member states. So the terminology, the interpretation vary drastically from a member state to another. And it's difficult, to bring very detailed clarity via a level 3 text of MiCA on a MiFID notion. So this is the first challenge. Another one is actually the thing that there is a set of regulation, different set of regulation of different approaches within the EU when it comes to crypto assets. We've got some ad hoc regulation, for example, in France. We've got some AML D5 type regulation, VASP regulation. And actually, those has led actually NCAs to have kind of strong views on crypto assets and the notion of crypto assets. And sometimes these views are not really harmonized. So no harmonization for financial instruments, different views for crypto assets. Well, we have to strike the balance here to provide clarity on one hand and not going beyond our mandate as an ESA. So sometimes it could be quite challenging, but still we are working on that specific topic. We were working with NCAs and with the industry. We try to actually find the main issues. We try to come up with some criteria, condition and criteria to have this classification. And we discuss also concrete use cases, but very useful to have these concrete use cases and to promote a convergence here and a common approach when it comes to this crypto asset that may be qualified as financial instrument or maybe qualify as a crypto assets. And actually, that's also a reason why we need actually your views, your technical expertise, and that's why we have published this consultation package. I mean, of course, level 1 works actually is done, so great. We've got maybe one of the most comprehensive regulation in the world when it comes to crypto assets. Now we need to focus on this level 2 and level 3 text, but we need to have technical feedback, not big words or narrative around blockchain is wonderful and it will change the world, etc. All that is very interesting, but no, guys, we need to just roll up our sleeves and open the hood of the car and do some mechanics. And to do that, actually, we need this very technical feedback. And for example, for classification, we definitely need this to understand actually how we can draw the line between those two class of assets, because in Europe, crypto assets are a new class of assets. But this work is still ongoing. We hope that actually the exchange will be actually fruitful, if I may say. And we are still working on that at the ESA level and with the NCAs, and we're going to try to promote convergence on this particular topic.
Yeah, I think it will be particularly challenge because in MiCA you have a positive definition of utility token in this Title 2, but I would say it's a narrow definition which has the only function of granting access to a service or a good. But this does not exhaust the category of tokens that undergo Title 2, and apparently it will be broader. But to what extent, this is a bit the issue that we have to understand. I want to make a comment, and then I give the word. I think in MiCA, given that we have MiCA, this distinction between financial instrument and crypto assets is not that dramatic, because in the end, if it's not a security, if it's not a financial instrument, nonetheless, we have an application of a set of rules with the white paper, which is quite protective for investor and consumers. And so I think that this distinction, which is sometimes very dramatic in our jurisdictions in Europe, it's not that dramatic, because in the end, people will be protected through the information that they find in the white paper. And I think that for the industry, it would be very important to have an harmonized indication about what falls under MiCA, and especially I would say for crypto asset service providers. I don't know if you want to comment on this problem. You have already mentioned it, Katie, like understanding to what extent is it possible to list tokens for a CASP, or also other challenges that you see with respect to the implementation of the technical standards for crypto asset service providers?
Yeah, I think from a firm perspective, I see the challenges around MiCA. I see them in 3 buckets. So the first is the path to a MiCA license, making sure that firms have equal access to a MiCA license, regardless of the member state that they choose to locate in. And then second of all, the level playing field issues, which we've already addressed, and I've provided some examples. And then the third bucket of issues I see as being these implementation issues, trying to understand the requirements of MiCA and implement them. And there are a number of issues where we're looking at the text and trying to understand how we comply. And I can give a few examples. So just one example is on the white paper requirements. We absolutely agree with disclosure to the market. We think that's a critical part of consumer protection. We also agree with MiCA that in the first instance, it should be the issuer that should publish the white paper to the market. But there's a provision in MiCA which states that where a white paper doesn't exist, the CASPs should step in and produce the white paper. Now, that's all very well, but the information requirements set out in MiCA are incredibly detailed, particularly in the annex. And there's a certain amount of information in there which we don't have access to. So, for example, it requires information on the financial position of the issuer. And so when we talk to member states or we speak to the Commission, they say the intention behind the proposal was that CASPs should provide white papers on a best efforts basis and on the basis of publicly available information. The challenge we have is that that's not necessarily what MiCA says. The information requirements are incredibly detailed. And again, that clarity from ESMA in terms of how CASP should go about complying with the white paper requirements would be incredibly useful. And I can give a second example, which is around asset segregation. So MiCA requires that firm and customer assets should be held separately on the blockchain, which we absolutely agree with. We saw the ramifications where that was not the case in FTX, where there was significant misuse of client funds. But again, I think there's recognition from a number of member states that the model adopted across the market is that there's this very small amount of firm funds that are kept in client omnibus wallets to support the operation of the market. So, for example, where we want to pay gas fees for a customer. And again, when we speak to member states, they say to us, we recognize that that's common practice and that makes sense. But again, it would be very helpful if ESMA could kind of clarify that for firms to implement, that this very small amount of firm funds can be held on in the customer omnibus wallet. And just to be absolutely clear, this is not about using customer funds for the benefit of the firm. It's actually the reverse. It's about being able to use firm funds to benefit customers and the operation of the market. So as I said, we see three buckets. It's about consistency in the path to a MiCA license. It's about level playing field across a whole range of issues, but also we see a significant role for the EBA and ESMA in terms of providing clarity to the market on some of these trickier implementation issues.
Yeah, thank you. The first point, I think it's very important. One has also to remember that attached to the white paper, there is also a regime of responsibility, liability, which for the first time is harmonized at a European level, because the prospectives regulation is an harmonized piece of legislation, but we don't have detailed rules on liability, whereas in MiCA we have them. And publishing the white paper means also taking the responsibility. And so the indication that we got is of importance, because you will not take a responsibility for something which you cannot really assess and control. And this should be taken into consideration. Now, it's a bit outside the scope of our panel, but I think it could be of interest for the audience. The scope of application of MiCA is limited, and I think that the two most tricky points are the application of DeFi and NFT. Obviously, if you give technical standards also to understand when a token falls under MiCA, it could perhaps happen that also something which we consider an NFT collectibles might fall under MiCA. At the same time, the description of services that fall under MiCA might also touch something which we could consider DeFi. And do you have this in mind while you're implementing your technical standards, or it's a problem that you're going to address in the future?
Yeah, no, of course, we've got all these problematic issues in mind, even when drafting the level 2 and level 3 text, even if there is no level 2 and level 3 text on these particular topics. I mean, for example, on NFTs, DeFi, or on staking, for example. But for sure, what we're going to have is we've got a mandate with the EBA actually to draft and to prepare a report by December 2024 on market developments with a specific actually focus on DeFi and NFT and some actually other important issue that may raise. So for sure, we are still working on that. For example, on decentralization. Of course, we do not want to preempt the current work of IOSCO, for example, on this topic, but still we need to actually at least have further clarity on that. As you know, there is one recital, I think it's 22 in MiCA, mentioning actually decentralization. Basically, it says that actually if your activity is fully decentralized, then you are out of scope of MiCA. But what does it mean, fully decentralized? And it means that also that if a part of your process is decentralized, but not all the part, then you could fall under the MiCA regulation. But this fully decentralized notion is not defined, not yet. It's more a question, I would say, for the European Commission, but still we are, of course, engaged in this topic with NCAs also and with the other ESAs. Same for NFT, even if for NFTs is a bit, it's clearer in the sense that it's quite clear that if your NFT is part of a large collection of large shares, then you could be qualified as a crypto asset service provider, because actually your NFT could be qualified as fungible, and then you could fall under the definition of a crypto assets. But still, this notion, we are also working on that. More clarity would be more than welcome, I would say, but still it's not really at our level to provide that clarity, because it's more level 1 job, and it's more for the European Commission. But still, with the EBA, with the IOPA, we are still working on that. And also staking. Also, we have a lot of questions on staking. Staking, as far as I know, is completely out of scope of MiCA, at least. But it depends what you actually define as to be a staking activity. Because staking activity involving, for example, custody, then, I mean, you could easily fall under the MiCA regulation because you are providing custody on behalf of your clients. So depending on which type of staking you are providing to your client, you can fall or not within MiCA. And that is very interesting and also very challenging with crypto, is that it's a lot of time, most of the time, I would say it's a case-by-case analysis. So you need to assess that on the case-by-case analysis. You need to talk with your NCAs. You need to understand we need to understand your business model, your tokenomics, all the criteria of your activity in order to put you in the right regulatory boxes. But of course, to answer your question, we are working on that. We have that in mind, and we hope that all together, the ESAs, the NCAs, and the European Commission will bring more clarity on that next year.
Okay, thank you very much. So we finished our time. I would say it was very interesting. Thank you very much for your insights, and we will see what will happen in the next months. We'll follow your work. Thank you very much to our speakers.